The Subcommittee on Courts, Intellectual Property of the Internet will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. We welcome our witness today, and we will introduce her at a subsequent time imminently. With that in mind, let me give my opening statement. Within Congress, the Judiciary Committee is responsible. Strike that. I want to apologize to all of you for our belated commencement time. We had votes on the floor. That's why we're running about 10 minutes late. Within Congress, the Judiciary Committee is responsible for overseeing and legislating on matters that derive from or are substantially affected by the Constitution's grant of authority under Article 1, Section 8, Intellectual Property Clause. In the context of today's hearing, there are 2 points I want to make regarding this authority. First, the Constitution's drafters didn't merely give Congress the authority to grant exclusive rights to authors and inventors. They gave the Congress the responsibility to execute it by literally prescribing the means of securing these exclusive rights. Secondly, since the 19th century, the Congress has sought to administer and secure these rights through a design that has largely been left unchanged, a statutorily created Copyright Office housed in the Library of Congress. Today's hearing will focus on the operations of the U.S. Copyright Office. In doing so, we will not merely gaze backwards to assess how the office has constructed its business in recent years. We will look forward and begin to examine the more difficult and substantial questions of whether we are equipping the office to succeed and ask what steps we need to take to position it to promote the interest of authors and the public and perform its statutory responsibilities in the 21st century. From time to time, we need to step back and see not only if we should make changes to substantive law, but also whether we should continue to do things as we have done them for years. On the substantive side, the committee is engaged in an ongoing and historic comprehensive review of copyright law. On the process and operations side, we need to begin a complementary effort to ensure that we are considering how to administer the law and whether we are furthering its constitutional and statutory objectives on a substantial basis. Over the years, I think the location of the office in the Library of Congress largely served the objectives and interests of both organizations and the American people as well. But we live in a dynamic and increasingly digital environment, and it's clear that the office's structure was designed for an analog era or an analog age. Today, the office serves as a repository for vital information that helps to promote and advance the interest of free expression, and as this epicenter of commercial activity that educates and entertains not only Americans but citizens throughout the world. This will only increase tomorrow. Congress has looked to alternatives in the past. In the mid-1990s, we contemplated reorganizing the PTO as a government corporation, and one of the proposals reviewed would have been to combine the Copyright Office with the PTO. We subsequently adopted reforms to the PTO's organization, but put aside the question of whether the Copyright Office, and more importantly, the principles we seek to advance through the institution of the office, would be of benefit, therefore. The subcommittee has been concerned about the office's ability to perform its functions and duties for some time. It is an open question whether the office has the support it needs from the library. And I don't mean that in any way critical of the library, but nonetheless, I think that's the case. Its operation and function of 24/7 as a marketplace requires that the American people deserve. This discussion needs to be a public one, and it needs to be approached with an open mind, with the clear objective of building a 21st century digital copyright office. We look forward to receiving the testimony of Mrs. Palatti, the United States Register of Copyrights. But before she begins, I want to note that she recently delivered an important address entitled "The Next Generation Copyright Office, What It Means and Why It Matters." In those remarks, she reported on the progress of the office has made in modernizing its operations under existing authorities and made recommendations for needed improvement. Without objection, I ask that we include a copy of that speech in the record. I'm now pleased to recognize, Mr. Dadler is not here, Mr. Conyers. I will recognize the distinguished gentleman from Michigan, former chairman of the full committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Coble. I'm delighted to join you in welcoming the Register of Copyright, and I would like to merely observe that this office plays a critical role in promoting and protecting the integrity and vitality of our nation's copyright system. And to that end, today's hearings should focus on several factors. As a fundamental matter, the Copyright Office must be on the forefront of our fight against piracy. As I have stated many times, copyright is critical to job development and the overall health of our nation's economy. An intellectual property system that protects copyrights incentivizes their owners to continue to innovate, and that in turn, of course, creates jobs and strengthens the nation's economy. Unfortunately, piracy is devastating to our economy and harms our creators and innovators. It is directly responsible for the loss of billions of dollars and millions of jobs. The Copyright Office helps to combat piracy by educating the public and Congress on the seriousness of piracy and how to prevent it, and it works with other agencies to strengthen copyright enforcement. In addition, the office, through its International Copyright Institute, helps deter piracy of copyrighted works by encouraging the development of effective intellectual property laws and enforcement abroad. Accordingly, we should encourage the office to further explore ways to strengthen its efforts to maintain a robust copyright system and combat piracy. A factor integral to the success of the copyright system is for the Copyright Office to upgrade to the digital age and become more user-friendly, and accordingly, we must support the office's efforts to modernize. For example, the office's recordation system continues to be a cumbersome and costly process that requires manual examination and data entry. The functionality of the office's databases and the usability of the office's website, frankly, need improvements. The security of deposited digital works should be enhanced. The copyright community needs a system which provides a more usable public record of copyrighted material. The Copyright Office is aware of the need to modernize, and we must help it do so. And most importantly, a strong copyright system requires that we fully fund the Copyright Office. And in that regard, the chairman of this committee, Bob Goodlatte, joins me in supporting that idea. The office performs several significant roles in our copyright system, including examining and registering copyright claims, recording copyright documents, and administering statutory licenses. Yet, since 2010, Congress has cut the Copyright Office's budget 7.2%, while continuing to ask the office to do even more. And as a result, the office has had to rely on its small reserve fund of customer fees to barely meet operating expenses. This reduces any operating cushion the office could otherwise use for long-term planning. Further, the recent sequester further compounded the resource problems at the Copyright Office. It limited the office's ability to hire staff to fulfill its many duties. In fact, just considering the registration program, it currently has 48 vacancies out of 180 staff slots, according to our research. And unless Congress can agree on a federal appropriations plan next year, the office will face another mandatory sequester in fiscal year 2016. Fully funding the Copyright Office will help it carry out the increasing volume and complex work that we expect it to perform. This, in turn, will make our copyright system become more effective and efficient. And so I thank Chairman Coble for holding today's hearing, and I look forward to hearing from the Register of Copyrights herself. Thank you, Mr. Chairman.
I thank the gentleman from Michigan. The chair now recognizes the distinguished gentleman from New York, the ranking member of the subcommittee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, for holding this oversight hearing with respect to the U.S. Copyright Office. I'd like to thank the Register of Copyrights, Maria Palante, for appearing again before the subcommittee, and thank you and your staff for serving as a resource during the committee's comprehensive copyright review. I look forward to hearing how the Copyright Office can continue to provide valuable services for both copyright owners and users, which is particularly important as intellectual property and copyright matters constitute an increasingly significant segment of our economy and culture. Many people might be surprised to learn just how many functions the Copyright Office performs. The Copyright Office registers copyright claims, records documents, administers several statutory licenses, performs regulatory responsibilities, and provides information to the public. In addition to these administrative functions, the Copyright Office provides expert advice to Congress, conducts studies, and makes policy recommendations. Over the years, the Copyright Office has given Congress a number of studies on a variety of topics, including orphan works, library exceptions, statutory licensing reform, federalization of pre-72 sound recordings, and mass digitization of books. The recent and ongoing reports and studies have been extremely helpful to members of Congress and their staffs. I'm particularly thankful for the updated report examining the issues surrounding visual artists and resale royalties in the United States that was released in December of last year. And I look forward to reviewing the music licensing report that will be released in the near future. The future success of the Copyright Office will largely depend on how technology at the Copyright Office is connected and managed through the library's technology enterprises. For that reason, I'm interested in hearing about how and if the Copyright Office's technical capacities are fully able to accommodate the long-term goals of the office. Electronic submission standards for copyright documents will also continue to grow in importance. The Copyright Office should continue to make recordation inexpensive and workable for copyright transactions. The Copyright Office has been able to perform their numerous responsibilities with very limited funding. In fiscal year 2014, the office had an overall budget of just $45 million, with about $28 million of that coming from fees paid by copyright owners for registration, recordation, and other public services, and $17 million from appropriated funds. The Copyright Office continues to face staffing shortages, budget reductions, and workloads, and as the distinguished ranking member of the committee mentioned, the sequester. With these challenges, the Copyright Office may need to consider creating new positions to support the complexity of statutory technology and regulatory responsibilities. Copyright owners depend now more than ever on searchability, reliability, and security of Copyright Office records. Copyright owners want to know that their digital files will remain secure as digital works become used more often. The Copyright Office and the library need to maintain secure repositories so that users can continue to have confidence in participation in the copyright system. I know this is a goal that is shared by Ms. Palante and her leadership team, who have taken steps to improve the core services and technical capacity at the Copyright Office. I look forward to hearing from Ms. Palante today about how we can continue to improve the Copyright Office and ensure that it provides state-of-the-art services in the years to come. I thank you, and I yield back the balance of my time.
I thank the gentleman. We've been joined by the gentlelady from California and the gentlelady from Washington. I think Washington, California, Evergreen State, and the distinguished gentleman from Pennsylvania. North Carolina, and Georgia. As I said earlier, we're honored to have the United States Register of Copyrights as our witness today. Marie A. Palatti is the 12th appointed Register of Copyrights and Director of the United States Copyright Office. In her position, Ms. Palatti directs the legal policy and business activities of the office. The position of the Register of Copyrights is a unique, historic, and vitally important one, and Mrs. Palatti assumed control of the office at an especially challenging and momentous time. Among other key duties, the Register serves as the principal advisor to Congress on matters of copyright law and policy. Ms. Palatti had spent much of her career in the office where she previously served as the Associate Registrar for Policy and International Affairs, Deputy General Counsel, and Policy Advisor. She also served as a Senior Advisor to the librarian, Dr. James Billington, immediately prior to being appointed Register. She spent nearly a decade as Intellectual Property Counsel and Director of Licenses for the Guggenheim Museums in New York. She earned her J.D. degree from the George Washington University School of Law and her bachelor's degree from Misericordia University. Madam Register, it's good to have you with us. We try to comply with the 5-minute rule, if possible. When you see the green light turn to amber, the ice on which you're skating is becoming thin. But you won't be penalized if you violate, but try to stay within the 5 minutes if you can. We're pleased to have you with us today.
Chairman Coble, Ranking Member Nadler, members of the subcommittee, I'd like to thank you, as well as Chairman Goodlatte and Ranking Member Conyers of the full committee for inviting me to testify today. The Copyright Office is a significant federal institution. We interact with and provide services to businesses of all sizes, from small proprietors to multinational corporations, many of which are in a state of constant growth and innovation. Never has the delivery of creative content been faster, more interactive, or more global than it is now. In turn, it has become clear to me that the Copyright Office must also become more forward-thinking than it is. That is, more flexible and more interoperable with the marketplace that we serve. In the past couple of years, I have focused the office on 2 primary goals. First, carrying out the day-to-day workload of administering the law, and second, engaging in discussions with the public about future strategies and direction for the office. Mr. Chairman, we have been very transparent about this work. We have published numerous public inquiries, we have solicited written comments, we've conducted numerous roundtables, and we've participated in dozens of meetings at bar associations, conferences, and seminars. In 2011, we published and have since followed a multi-year work plan. This included a series of special projects designed to inform the priorities and future path of the office. Notably, this occurred alongside budget cuts, further challenging us to not only think big, but to think creatively about our operations. Here are some of the highlights of what we've accomplished. We analyzed and wrote the first revision in decades of the Compendium of U.S. Copyright Office Practices, which we released in draft form to the public last month. At 1,200 pages, the compendium is replete with our core administrative practices and helpful examples for authors, artists, and other customers. It is the instruction manual for our staff in the examination process, and it is a key legal source for the courts. We have received tremendously positive feedback regarding both the authoritative text and the clear presentation of the material. I would like to underscore some of the groundwork that we have done in the area of technical upgrades, which was really a form of self-evaluation for the office. Essentially, we conducted a public review of our relative strengths and weaknesses in providing services with a focus on the user interface of our electronic systems, the quality of our public records, security issues, the usability of our website, industry standards, for example, with respect to metadata, copy controls, and private registries, and the overall customer experience of interacting with the office. We spent considerable time evaluating our recordation service, which Ranking Member Conyers has pointed out is still a paper-based process. Recordation is separate from registration. This is the process by which licensing information, security interest, and other copyright documents are recorded with the office on an ongoing basis. We need to transform it from a paper process to an interoperable digital platform. We are grateful to everyone who has participated in this work, including book publishers, public interest groups, technologists, the music and movie industries, photographers, authors groups, and others. Turning to my final point, I want to discuss our budget, which in turn affects staffing and technology. As mentioned, we have a $45 million budget. About $28 million of that comes from fees. In May 2014, we implemented a new fee schedule following a 2-year public process, raising the general fee for registration from $35 to $55. We did retain a lower fee for certain small actors. This was the first time we have ever differentiated our fees, but there has been strong public support for the concept, and I think we probably have to do more of it in the future. To be very clear, and notwithstanding the direction of our statutory mandate on fees, I should note that the Copyright Office fees do not recover the full cost of our services. This is because we share IT infrastructure with the Library of Congress and receive our IT support services from a central library department. If we want the public record to be better, we will need better resources. And if we want the resources to come primarily from fees, then we should expect that copyright owners will in turn want better systems and services than they have now. Moreover, under the current statutory language, we are limited to charging for the cost we incur for providing services. That is, our fee authority does not permit the office to collect for capital improvements or other forms of investment above actual cost after the IT infrastructure that is subsidized by the library. This equation may be something that Congress wants to visit. In terms of staffing, I'll just say the Copyright Office is smaller than it should be to carry out the volume and complexity of the work that we are charged with. Unfortunately, as the staff has been reduced, the work of the office and the complexity of the copyright system have increased dramatically. Chairman Coble, that concludes my statement, but I wonder if I might have a minute on a different point.
Without objection.
Chairman Coble, I am aware that you have presided over copyright issues on this and former committees for close to 3 decades, including as chairman. As you prepare to retire, I am moved to say that today may well be the last time that a Register of Copyrights will appear before you. Therefore, on behalf of myself, my predecessors, and the entire staff of the U.S. Copyright Office, I wish to personally thank you for your dedication to our nation's copyright system and for your service to us. We will miss you tremendously, as will the rest of the copyright community. Thank you.
I'll give. Thank you. I appreciate that. Thank you. Thank you for that. You all know how to make an old man feel good. I thank you very much for that, for your generous words, Madam Register. I appreciate that. Appreciate the response for the audience as well. It's good to have all of you with us today. And I think you beat the time frame too, Madam Ms. Palenti. I think you beat the illumination of the red light. Understanding there are many different views on substantive copyright law issues, do you think, Ms. Palenti, there is a general agreement on the importance of ensuring that the office itself is properly resourced and modernized for the digital age?
Well, Mr. Chairman, I haven't heard anybody say stop looking into modernizing your operations and don't bother going into the 21st century. So in answer to your question, I think copyright owners have legitimate concerns about our services, many of which were designed in the analog age. And I think the tech sector would like to see our database be more interoperable and authoritative so that they can also rely on it for their work in the chain of commerce.
Thank you. Old habits die hard is why I put the question to you. Do you have any business plans or credible estimates of what it would take to build a substantial 21st century digital copyright office?
I'm afraid I don't, in part because I think we have the same fee structure we've always had, which doesn't, I would need to work with you and work with the committee to figure out what portion of that should be fees and what portion of it should be appropriated dollars, because there are things that we can do that are reasonable and there are things that we can do that are really incredible, and we may have to figure out what the goals are together. I will say that when the electronic system was implemented in 2008, it was before my time, it was, I think, reasonably intertwined with the library's existing enterprise. I think that subsidy has made it difficult to figure out what our actual costs are. So in other words, we share that with the entire library as a cultural institution, and trying to figure out what portion of their budget is attributable to us is not something that has really been done. That kind of cross-accounting has not been done.
Well, thank you for that. Yesterday, Madam Register, it was reported that Representative Greg Walden criticized the FCC for having spent $352 million on IT over the last 5 years. How much have we spent on the Copyright Office during the past 5 years, and how much do you think we've dedicated to the office's IT for consumers?
We have a very, very minuscule budget for IT because our IT department has 23 people in it, plus a number of contractors. It really is a liaison office to the library. The library's IT budget is somewhere in the neighborhood of $60 to $100 million. You would have to ask the library how that breaks down completely. So again, we don't have a mature, independent IT structure in the Copyright Office. We have people who help to develop software modifications to existing programs.
Thank you. Thank you again, Madam Register, for your generous words. I appreciate that very much. In fact, for the record, I think our subcommittee has enjoyed very excellent rapport with not only you, but your immediate predecessor. Remember me to her, if you will, when you see her. I'm now pleased to recognize the gentleman from New York, Mr. Nadler.
Thank you very much, Mr. Chairman. Madam Register, can you outline some of the steps that have been taken to improve the copyright registration system in light of the fact that many businesses offer works by streaming or displaying them via an array of technologies?
Yeah, this is one of the issues I think that keeps the leadership of the Copyright Office up at night. We are dealing with kind of multiple problems. We have an electronic interface for registration, but that is based on the paper-based system. In other words, the paper system was transposed into an electronic interface. We have yet to go to the next generation of really having kind of the real advantages of a 21st century digital system. We also have a statute that was written in enacted in 1976, written for 20 years prior to that. And it envisions a system of analog works. So it envisions a process by where you send us works, we examine them, they're available for the library's collection.
Does that statute need to be revised to account for digital?
I'm sorry?
Does that statute, did you just imply that you are mandated to do things in analog and that we should revise that to allow for digital?
I didn't quite say that. What I said is that the statute did not anticipate the tensions that we have now that works are digital.
Okay. I think you may have just answered part of the next question, which are what are some of the improvements that may be needed at the Copyright Office in the future?
Yeah, I think we really need to figure out, first and foremost, what we want the registration system to be. So we may not need the best possible quality of a work for purposes of examining it and keeping it safe for litigation purposes. That best copy concept was designed for the Library of Congress so that it could preserve and have access to the best work available in the marketplace. The library has separate provisions, like every national library in the world does, where it has the right to acquire copies of published works for the national collection. That's different than registration copies. What we have done in our copyright system, and it was done to protect copyright owners, or at least to relieve them of the burden of having to comply with dual systems, was say that if you register, we'll use those copies for purposes of the provisions regarding the national collection. I think where we are in the Copyright Office is, do we now need to kind of step back and maybe segregate those provisions so the registration system works for copyright owners and the public record, and the library has very clear regulations and statutory instruction about what it can and cannot acquire. And if it does acquire digital works, and I wanted to say for a moment, the Library of Congress is an incredible cultural institution. and it has actually preserved works that copyright owners have failed to preserve over the years. But assuming you want it to have access to digital works in the future, we do need to have safeguards because we're talking about copyrighted works.
Well, that was my next question. How will the Copyright Office be able to meet the challenge of enhancing the security of deposited digital works?
We really need to apply our all hands on deck on this question. Operationally, we share servers with the library, and I don't think we, well, I know.
Danger to the security?
Yeah, I think so. I mean, nothing insidious and terrible has happened, but it's certainly a risk. And again, it goes back.
Should we consider severing your sharing that with the library? And would that be very costly?
I think optimally we should have separate servers for the registration system than the library has for its other business, yes.
And do you have any, are we talking millions, billions, thousands?
Well, here's the question that I grapple with. What is the reasonable cost of a registration system if the copyright owner and the public are getting the kind of return that they want? And if we're not charging $55, but we're charging for some,
I'm sorry, you misunderstood my question. I'm not asking the value. Order of magnitude, what would it cost to give the office separate service from the library?
What would it cost as opposed to how to fund it, you're asking me? I don't know.
Order of magnitude, are we talking millions or $500 million, or do we have any idea?
At a very high level, in terms of modernizing the office, I think it's an investment of somewhere in the neighborhood of $150 million.
Over a time period.
Of that, you could say you must charge, half of that must come from fees. Do some public-private partnerships, be creative.
And my last question, since I've got the orange light, how has the registration program been hurt by budget cuts and early retirement packages?
It's really been cut to the bone. We have huge vacancies, and we have the kind of staff that requires several years of training to get them to the point where they're applying the law and the regulations and the compendium accurately so that courts and others can rely on it. So they're really exhausted, and then they're dealing with an electronic system that sometimes crashes, doesn't work all the time, and isn't anywhere near the generation of services that copyright owners want.
So we're talking about both operating and capital costs there.
Correct.
Thank you very much. My time is
Thank you.
expired, Mr. Chairman.
I thank the gentleman, the distinguished gentleman from Pennsylvania.
Thank you, Chairman.
Right.
Good afternoon. The U.S. Copyright Office was created in 1897, I believe. Then music was written on paper and recorded music was listened to on a phonograph, starting with wax records, so to speak. Music creators and listeners use computers and mobile devices to create, distribute, purchase, and listen to music. So, could you please tell me, would moving your office into the 21st century cut down on unnecessary litigation, and how?
Yeah, sure. Our role, I think, in the 21st century is to have the most authoritative, accurate information about copyright ownership and licensing terms available anywhere, globally. And if people can find that kind of information by clicking on a record and getting the licensing terms and being sent to a private registry, you begin to see how our role can really facilitate the licensing marketplace.
The Copyright Office is not an agency or even a sub-agency, and you do not report to the President, correct?
Correct. I report to the Librarian of Congress.
Okay. How would your office in the United States be seen internationally if your office were independent, its own entity?
Well, I'll say two things. In deference to all of the registers that have come before me and all of the talents that they had, the registrar position is recognized internationally. But we have this system with our own interagency process where we have people from PTO and elsewhere in the administration really leading the international discussions on copyright law because of our unique situation in terms of where we're seated. So, presumably we would have more authority and recognition if the position were different.
Could you give me an example? Could you give us an example of if you need to do something in your office, whether it's equipment-wise, whether it's rearranging more space, anything at all, what is the process you must go through?
Well, again, we're a department of the Library of Congress, like every other department in the Library of Congress. So for all of those kinds of infrastructure questions, they go through central library practices and processes.
And with all due respect to my colleagues at the Library of Congress, which are fantastic because every time I need something, they're on it just like this. But you are a copyright lawyer?
Yes.
Intellectual property lawyer?
Yes.
I'm making an assumption here, and I think it's rather accurate. You are the expert over there, but yet you have to go through an unorthodox chain to even make your office operate back in the 19th century standards, correct?
Yes. So another way to look at that, I think about this a lot, as you might imagine. There is no position in the government like the Librarian of Congress. It would be a little bit like having the head of the Patent Office also run the Smithsonian Institution. And constitutionally, that is the situation that you have. And I would say for almost 120 years, it's served the nation fairly well. What we're experiencing now is an explosion of the prominence of the copyright system. And so I understand this to be about what's best going forward.
Well, no matter where we go today, my kids, my mother, who is 82 years old, carries one of these and does all kinds of things on it. And you're still in a position where you're looking at documents. So I'm speaking on, I think, behalf of a lot of my colleagues. You need to be brought into the 21st century. You need to be an independent entity. You're a part of the executive branch. And I think your job is so important, and you've done such a fantastic job, as your predecessors done. I think you should be report to the president and have your ability and your foresight. I'm sure you could take that office into the 22nd century for us. So thank you, and I yield back.
Thank you, Mr. Marino.
I thank the gentleman, the distinguished gentleman from Michigan, Mr. Conyers. Mr. Conyers.
Thank you, Chairman Coble. We've appreciated you coming before us and explaining your circumstances. Ms. Pallotti, in your written testimony, you mentioned a 7% decrease in the office's budget since 2010. What effect has that had on the ability of the office to fulfill its duties? And are there other financial constraints that you believe are limiting the office for running more effectively?
Thank you, Ranking Member Conyers. So we immediately, one of the first things I experienced as registrar right after my appointment was to do an early out buyout for to move people into retirement who were willing to do that, to reduce the staff. I will say that is not necessarily a terrible thing to go through, because we have a lot of people who work for decades in the Library of Congress and in the Copyright Office, and it creates the opportunity after those good years of service to rethink positions, digital positions, instead of, say, catalogers. The problem is we can't replace them because we don't have the budget to fund them. And we're really, really small. I think we are smaller than we have ever been in modern times. The irony for us is that we are busier than we have ever been.
So creating a more aggravated problem. Well, since 2008, the Copyright Office has moved into an electronic registration system. How has that worked out, and what needed improvements might there be required?
Yeah, that was a big moment for the Copyright Office. It wasn't on my watch. I was still in New York in the private sector, but I think our issue is that we haven't moved past it. That was a good foundational first-generation system. We haven't gotten to recordation. That's still paper-based. And we haven't made the registration system truly interoperable, meaning that we can't necessarily have people send us deposits of their works because we can't accept them, because our system won't handle them. We don't connect through metadata to ASCAP or BMI or Sound Exchange or other registries.
So what do they have to do?
We need to rethink the whole thing, drawing on the tremendous expertise of the copyright community from here to California and back.
What has the office done to rectify current issues with recordation, and what are the major concerns there too?
Okay, so we've done everything we can do without money. We ran numerous public processes asking people what the system should look like in the future. We had dozens and dozens of meetings. We had 3 public hearings, one in New York, one in LA, and one in Silicon Valley. We assigned to the first Abraham Kamenstein Scholar in Residence, which is a program we started based on the one of the registers who presided over the 76 work leading up to that act. The task of really thinking it through as a scholar, and he's finalizing his report. And now we have options, and the question is how to get to a strategic plan, given budget cuts, but also the infrastructure that we have. And do you want to invest in it the way it stands currently?
Well, we know that you need help fast. What do you see is going to happen if you don't get the funding that you need?
Well, there's already a significant gap between our services and the way the copyright marketplace actually operates. So that gap will grow. I will also say, though, as kind of the head of the staff of the office, this sounds like a weird term, we cannibalize our staff, right? The same people do everything. They register, but then they're writing a compendium that's 1,200 pages long. They're running trade negotiations with USTR, helping Congress, writing significant regulations, and we just aren't big enough, and we don't have the depth of experience that we need.
Thank you very much for
Thank
your
you, sir.
candor. Thank you, Mr. Chairman. I yield back.
I thank you, Mr. Conyers. The gentleman from California, the distinguished gentleman, Mr. Issa.
Thank you, Mr. Chairman. Boy, I'll tell you, hearings like this let us know how long it takes to do anything here on Capitol Hill. Let me run through a couple of quick questions, because I think the public and all of us want to sort of make sure it's in the record. Currently, if I write a book, I can send 2 copies of the book to you in paper, and you'll take them, and then I have a copyright, right?
Correct. You have enhanced protection, in fact.
Yeah. Or I can do nothing, and I have a copyright. Is that right?
Correct.
What do you do with those 2 books?
We have a repository by regulation, or the library has the ability to inspect and acquire those deposits and then use them under applicable law.
Okay, which means
That's statutory.
means I can check out one of those 2 books because it's my library after all, or all of our library.
The Library of Congress has arrangements with other libraries, and
So for a little over 100 and some years, this has been kind of how it works. You send your 2 books in, and Congress can get smarter, and you've got the capability. There was a time when you had to send them in to have a copyright. Works that were not sent in simply enjoyed no copyright protection. When did that change?
Yep, they went into the public domain. We moved that system for international compliance purposes, or to become more internationally harmonized with the 76 Act. That was a sea change for the United States.
So basically we took those things which people wanted to protect and turned it into everything is protected.
That's one way to look at it, for sure.
And this is interesting because we did it in harmony with the rest of the world that normally doesn't respect these things very well. So always interesting. And you already stated that we haven't come into the digital age particularly well, because if I want to make sure you have copies of everything digitally, every day, every newspaper, et cetera, you're not prepared to accept those.
It's difficult.
Well, it's difficult is an interesting thing. We say that a lot in Washington. If the Wall Street Journal and 400 other newspapers tried to send you either in paper or digitally One copy digitally, 2 copies on paper every day, you couldn't handle them, could you?
Well, we don't handle them well, so we accept them, we register them, but here's where we're going with our
Look, I
vision.
saw Indiana Jones and the Raiders of the Lost Ark. They accepted the Ark, too, in that movie. And they've got their best people working on it.
That's right.
We're here today because you represent the most arcane part of government in many ways.
Thank you.
We budget one part, we have you report to somebody who, in fact, doesn't really have the same mandate. Well, over at Department of Commerce, we have the primary oversight that we do, which is the Patent and Trademark Office. Now, I'm not going to put you on the spot, but if hypothetically we harmonized the functions of the PTO and harmonized your functions in some acceptable way, wouldn't that enhance the efficiency of dealing with digital and non-digital media, dealing with copyright, trademark, patent, and, if you will, the potpourri of evolving intellectual property?
I think so, yes.
Wouldn't it also harmonize or improve, assuming that they all work together, what happens when there's a alleged copyright violation and people want to get to justice? You don't have administrative law judges, do you?
No.
They do, don't they?
We don't have enforcement authority of any kind.
So we're dealing with 1897 thinking, even after a 1976 enhancement, which, by the way, there was an internet then. It just wasn't available to anybody in the public. So just to wrap up, budget is always a problem, but you're not even beginning to be positioned to handle well the absorption, the cataloging, the referencing, and the searching of the media being produced in the United States, let alone the rest of the world.
I'm afraid that's accurate.
And in a digital age, if we're going to protect copyright and we're going to make, if you will, works available to the public, both of those have to change.
Yep.
Now, let me close with just one question, because everyone's talking about, well, maybe we ought to just move you to a PTO. But let's ask one question, because I think it's more complex than that. Isn't it true that the function of the Library of Congress to enhance and make available for education and informational purposes, the United States and ultimately the world, that's a mandate the librarian has?
Yes.
And yours is, of course, the protection. Don't we have to modernize both of them? The availability that the librarian has and the systems for protection, including metadata that allows for searches, aren't those both things that have to be done on this Congress's watch?
Yes, I think that's an excellent way to state it and a very fair way to state it for the library. They need to be a 21st century institution as well. They're a leader among cultural institutions.
Thank you, Mr. Chairman. I think we've outlined some of the problem.
I thank the gentleman from California, the distinguished gentle lady from California, Ms. Chu.
Thank you, Mr. Chair. I think most people are surprised and perplexed when they learn that our nation's Copyright Office is housed under the Library of Congress, because your missions are very different. The library is focused on preservation, while the Copyright Office is focused on recording and registering works, and most importantly, instituting legal and economic rights protections. And your technical needs are so different because the library is that of preservation, whereas your office functions like a 24-hour business that intersects with the global marketplace. And I've been astounded to learn of the implications of this. First, you, the registrar, are authorized to establish regulations, but such regulations are subject to approval by the librarian, whose specialty is not copyright. Secondly, you are able to collect fees, but you have no control over what happens with those fees. In fact, they are managed by the library staff. Thirdly, on security, the Copyright Office should be ensuring the security of works, including digital works, but the mission of the library is to share works with the public. And finally, there is the issue of the appointment and authority that you have. Similar positions such as yours, the Intellectual Property Enforcement Coordinator and the Executive Director of the Patent and Trade Office. This is a presidential appointment, and you report to the President, or they report to the President. But instead, your position is appointed by the librarian and you report to the librarian. So can you talk about these specific challenges and how they impede your desire to make the Copyright Office thrive in a digital economy and support a modern copyright system?
Yes, thank you for those questions. I will say this. Everything that you set forth is true and was relatively without incident for a long time, decades. No, didn't cause any harm. I think, again, we're now seeing kind of growing pains and natural tensions between the library as a library and the Copyright Office as the copyright system of the United States. So I do feel like we're at a point where there either have to be safeguards put in place within the current institution, or you need to really think on this committee about new paradigms, maybe some of the things that you were discussing earlier. Interestingly, the IPEC was created recently, right, 2008, and the undersecretary, mid-90s. Those positions intersect with the registrar's authority by statute, but you're correct that they are much higher elevated than the register position is. And I think what you're really asking me is who's really the head of the copyright system. And the truth is the Librarian of Congress is the head of the copyright system for purposes of the Constitution. The register works under the general direction and supervision of the librarian. So there are many duties in the Copyright Act that say the register shall, but at the end of the day, it is really your librarian, all of your librarians back to 1897 who have had responsibility for the system.
And so, to be specific, I brought up the example of regulations that are written,
Yes.
fees, and security of works. Could you explain
Yeah,
that?
and you know, I don't know if this is so different from agencies outside of the IP space, but basically the expert in the agency, and you know, in turn my experts on my staff conduct rulemakings, prepare regulations. We work under the APA by statute. The library doesn't, but I send them to the librarian for signature, and he has to approve them. So it really isn't just a rubber stamp, and that is how it works. There could potentially be a conflict in the future. We haven't had that really to date. So I think, again, if we're talking about the future, that might be a better way to think about these issues. But for example, if the register were to say, I don't think we should be accepting digital deposits without copy controls in the registration system because it's a conflict for the statute and for the people registering, technically the librarian has a right to say, that's what I want.
In fact, can you guarantee the security of digital works right now?
No, because we don't have, well, I can't. I don't have control of the IT system. My avenue for that is to make the case internally. And, you know, in defense of the Library of Congress IT department, they are doing a lot of different things. We are not their only client or customer.
And what are the implications of not having control over your own fees?
It's a legal question. People are paying us for services, and that money is routed through centralized IT systems. So on the one hand, you have synergies. On the other hand, you don't have control of the product that you're delivering for those fees. And so what stakeholders have said to me is that we're talking about some stakeholders who invest tens of millions of dollars in their copyrighted works. So a $55 fee is not a big deal for them. And I think if they were getting the kind of service that they want and the security and confidence that they want, they would pay more. And I think that our fees are too low for those kinds of copyright owners.
Thank you. I yield back.
I thank the gentle lady from California, the distinguished gentleman from North Carolina, Mr. Holding.
Thank you, Mr. Chairman. Ms. Plante, thank you for being here. I think either in your testimony or in response to a question, we were talking about the office functioning as the principal advisor to Congress on copyright law and policy, domestically and internationally. And you also, have a duty as the Copyright Office to provide information assistance to other federal departments and agencies and the judiciary on copyright law. So with all of the happening issues in copyright law, I was wondering, how many lawyers do you have assigned to these discrete tasks, and what percentage of your work is this duty that you have to provide advice to us and others?
It's a huge percentage of our work right now because you've had 16 policy hearings in the last couple of years. We have 18 lawyers in the legal departments. A couple of people are actually lawyers at the heads of other departments, but the people doing the legal and policy work number about 18. That is not enough, and we have a particularly acute need for very experienced copyright lawyers who can run the kinds of significant public rulemakings and discussions and policy studies that we're responsible for. We do everything. Regulations alone could keep that number of lawyers constantly engaged, and that doesn't count getting on a plane and going to Vietnam to help the USTR negotiate a Pacific Rim trade agreement. It doesn't include meetings at WIPO where we're required to be. It doesn't include thinking through the legal implications of the things you're asking me about, fee structures and technology. So we don't have enough people.
Right. Are you able to supplement that at all? I've heard you mention.
Yeah. So again, we're really good at trying to do things with no money. We've gotten really good at it in the last couple of years. We created a couple of programs to supplement our staff with short-term cost as opposed to long-term staffing cost. One is the Kamenstein Scholar in Residence that brought a scholar to us for a year. We'll now try to get another scholar to come. That helps immensely because they're extremely capable and talented and quick and can do all the kinds of deep thinking that we need. We created the Barbara Ringer honors program. We got hundreds of applications. We just last couple weeks ago started our first 2 Ringer fellows, one from New York and one from Chicago. We created a Copyright Matters program to kind of bring people into the office to help us think about marketplace issues. Chairman Goodlatte has spoken at that. We've had artists. We've had presentations on fair use. And finally, we created a partnership, research partnership with law schools. And our first success with that was Stanford Law School, where 2 classes in a row under the tutelage of Professor Paul Goldstein, who's a giant in the field, worked on some of our recordation challenges. So, we're trying every which way to bring in talent and support to supplement.
Right. Mr. Marino brought up the issue of precisely where the Copyright Office sits in the structure of government and who it answers to ultimately. And I was wondering with the very important role that you play as advisor not only to Congress and the other agencies on copyright law, is the stature of the Copyright Office within the structure of the government sufficient? Does it impact your leadership role as you're trying to foster our American copyright system?
Well, that's a big question. I think over the decades prior to this recent period that we're in, the Register was given a lot of deference, but you created 2 positions that now are intersecting in copyright policy in the past 20 years. One is the IPEC, and one is the Undersecretary for Commerce, which is the head of PTO. It's a complicated structure because the PTO's statute says that the head of the Patent Office must confer with the Register on copyright policy issues. But I think what you're asking me is the head of the Copyright Office at the upper echelons of the federal government in the administration like these other positions? And the answer is clearly no.
You got a seat at every table that you want to sit at to influence policy.
And many stakeholders have said that to us, and we don't take it personally. But the answer, of course, is we're not.
And how does that inhibit, you carrying out the responsibilities that you think that Congress has vested you with?
I think we're not in the room all the time, right? We're not leading the delegations as the substantive agency. We're not necessarily in all of the discussions of the administration. We're a little bit confused about which branch of government we're in following this IBS-CRB case that came down and said all of our functions are executive branch. So I think, it's a complicated structure, and to be fair to my staff, I think people make it work at the staff level across this interagency process, but nobody really understands it.
And, if indeed, which I think you are part of the congressional branch, the legislative branch, whether or not there's a fiduciary responsibility or not, I don't know if we got that, but, perhaps us in the legislative branch are not being adequately represented because of your exclusion from some of these tables where policy is being made.
It's a fair point.
Thank you. Thank you, Mr. Chairman.
I thank the gentleman from North Carolina. The distinguished gentleman from New York, Mr. Jeffrey, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. Palante, for your presence here today as well as for your leadership. I think I want to pick up where my colleague left off and ask you about the recent IP or IBS versus Copyright Royalty Board case. I believe you're familiar with the case. You referenced it in your written testimony, correct?
Correct.
And the case involved a decision by the D.C. Circuit, I believe, that held that in promulgating copyright regulations, setting rates and terms, the Library of Congress is undoubtedly a component of the executive branch. Is that correct?
That's what the case says.
Now, it was already a complicated mix related to your structure as discussed during this hearing. How does this decision impact what was already a complicated situation? How do you interpret the decision, and what guidance can you provide to us as to how we should interpret the decision and what it means in terms of how we move forward?
Thank you. I think it's a fairly significant decision. On the one hand, it confirms that the Library of Congress is like no other agency in the federal government, in that it is a clearly hybrid agency. You've got the copyright functions clearly, in the court's opinion, being executive branch in nature. And then you've got, for example, the Congressional Research Service, which can only be legislative in the same agency. And as I said earlier, I think you've got this position where the Librarian of Congress is really a kind of incredibly Herculean job, where you're running kind of library functions, legislative functions, and then also executive branch copyright functions. You're right that these issues are not new. One of the things that's very interesting to me is that from 1802 to 1897, the Librarian of Congress was not a Senate-confirmed position. It was when Congress in 1897 formalized the copyright system within the library that Congress, and it's very interesting to go back and read this, speaking about constitutional issues that have now popped up again, said these issues must be constitutionally correct. They must flow constitutionally, so the Librarian of Congress must be Senate-confirmed. The copyright system affects the legal rights, economic interest of those who rely on it.
Right. Well, the copyright system, in fact, or Congress's power to legislate copyright and intellectual property, indeed stems from Article 1, Section 8, Clause 8 of the United States Constitution, which is, I gather, the reason why Judiciary Committee's got jurisdiction over this very important area of law. Now, you mentioned in your testimony that that the agency finds itself in a situation where copyright issues have become increasingly complex, and at the same time, resources have become increasingly strained. Very difficult situation to be in. Could you clarify what has increased the complexity of the copyright landscape?
Well, the digital revolution has made it more complex. And so where people used to, in the chain of commerce, work with analog physical items, CDs and books and DVDs, they are now getting their content on mobile devices and digital platforms. And so copies may not be involved. It may or may not be a generational thing as well. I happen to have teenagers. They don't want to own anything. They just want access to it. So it's it's this real focus that on display and access and streaming, making the public performance right arguably more important in the future than the reproduction right and distribution rights have ever been. And so we have all of that kind of coming into the mix, and then that requires us in our registration system to also make those shifts. How do we examine a work that is really only made available to the public through streaming?
Now, given the increased complexity, as you've laid out, and I think in a manner shared by a significant number of people in this institution, clearly, in my view, that suggests that we've got to look at providing the agency with the resources needed to deal with an increasingly complex landscape. But does the complexity also suggest, in your view, that it's reasonable for us to take a hard look at what an appropriate structure would be in the 21st century?
I think you have to, and I appreciate the question. I'll say it this way. A 21st century legal framework requires a 21st century agency, and the structure, the budget, the IT, the principal duties, the stature, all of those come into play as you look at the question, I think.
Thank you very much. I yield back.
Thank you.
Thank you. The chair now recognizes Congresswoman from California, Ms. Lofgren.
Thank you, Mr. Chairman, and thank you, Madam Registrar. It's good to see you.
Thank you.
You know, as we are enmeshed in this 6th triennial review, it just reminds me of Congress's obligation to reform Section 1201 to prohibit not only infringing action and to not tie up innocent use. You know, I think in a way we've had an opportunity to do some experiment isn't the right word, but to see what happens when legitimate content is offered and pirated content is available. The public goes to the lawful content. I mean, there's always some outliers, but in overwhelming numbers, that's what the public wants to do. And I think that is something we didn't know for sure, but I think it is a very welcome discovery. I think we've also seen that when we don't too tightly tighten up the circumvention, we promote innovation. You take a look at the app market, for example. It's just exploded in terms of creativity when we have not tamped down as you could have using Section 1201. So I think it's certainly not your responsibility, it's our responsibility to make sure that we go after infringement, but that we do not squash technological innovation that has nothing to do with infringement. And it's something, it's like a broken record. I've been saying that for more than a decade, but it's time for us really to do that. And I think the facts and the developments prove that we don't have to be afraid of doing that. Just a couple of quick questions. In the notice of inquiry that your office released yesterday, I was surprised, honestly, to see the intent to require separate petitions for each type of wireless device, tablets versus readers versus hotspots versus smartwatches, and even a distinction between different kinds of wirelessly connected e-readers and tablets. And it strikes me that this is wrong. Now, by dividing or subdividing wireless devices into different categories, it seems that the government would be protecting not copyrighted work, but business models. And that's not our job. Our job is to provide protection to material that is protected under copyright. It's not to pick winners and choosers among business models. So I have a deep concern about that. And you know, there was a huge uproar, as we know, about the ruling last year on not unlocking cell phones. The committee has even addressed that, although not as successfully as I think we had hoped. I think we're getting potentially into a much bigger outroar if we go into distinctions between different kinds of readers and the like. And then the second question, and then you can answer both together. The timeline given in yesterday's notice, I think needs review. You mentioned the role of law schools and law clinics, and I think it's a good sign, actually. And Stanford is not in my district, but it's 10 minutes out, and it's a great group of young students. The timeline, as published in the notice, has everything to do at Christmas. And the law clinics that are heavily supported by students are going to be adversely impacted by that time frame. And I'm wondering if we couldn't revisit that because the students, either they're not going to have a break or they won't be around, or it's going to be an insane type of workload that we're putting on them. It's 45 days after the notice of rulemaking. I think we need to revisit that, and I welcome your comments on both of those questions.
Yeah, sure, thank you. Just say on the last question, we frequently extend deadlines once we publish them. Usually when a few stakeholders call and say what you just said. The timeline was orchestrated working backwards from when it's due.
But if I could on that point,
Sure.
from the student's point of view, knowing there's an extension later isn't going to help them.
Yeah, no, I understand.
They
So-
need to go to the max doing all-nighters while their exams are due, unless they know it's going to be extended.
Yeah, and we obviously want fresh, young, talented students participating. I hear your point. So I will talk to my general counsel's office and we'll look at the timeline. On the first point, you know, it's interesting. We spent a lot of time talking to everybody who has participated in this proceeding over the past decade and consulted with the administration about how to do it better than it's been done before. And a number of changes were made with that in mind. The subdividing of the different categories was intended to create a better record because the lack of a good record was our problem in the last round. And we were trying to get people to focus on what the evidentiary standards would have to be. So it doesn't necessarily preclude us from finding that there are multiple devices and categories that will have like treatment in the end. But the intent was to do something to improve the situation, not to make it harder.
I guess I don't understand that, and perhaps you can fill in later with me, but if you take a look on page 55689, it talks about a petition proposing a general exemption for all wireless devices or all tablets. It's difficult to support in contrast with tablet computers, e-book readers. It just seems to me that it doesn't, from Silicon Valley point of view,
Yeah,
that doesn't make any sense at all.
I can see how it wouldn't make sense from a technology perspective. It's we have this factor in the statute that requires us to look at actual markets, not giant markets, but particular markets. And so, to your more general point, the 1201 rulemaking is from 1998, and we're trying to fit it into.
No, and I understand. I love Bob Kastemeyer. When he wrote the act in '76, he didn't have to deal with some of these issues. But the fact is, in terms of markets, whether I have my Kindle, whether I have my iPad with my Kindle app, whether I have my Kindle app on my phone or my Galaxy phone, it really doesn't matter.
Ladies, time's expired.
Thank you, Mr. Chairman. I hope that we can follow up with this because we are likely going to have the same ugly explosion and public outcry that we had last year on phone unlocking. It'd be nice to avoid that.
I thank the gentlelady. This concludes today's hearing. I want to thank the Register again for having served as our only witness today. We appreciate it very much. I want to thank those of you in the audience. Your presence indicates that you have more than a casual interest in this matter, and I thank you all for hanging tough as well. Without objection, all members will have 5 legislative days to submit additional written questions from the witnesses or additional materials for the record. This hearing stands adjourned.